Hi, welcome to Family Law with Justine. Today I'm going to talk to you about property settlements and the range of divisions that can be made in various cases.
Justine, I, along with many people, just assume that as a family law client, my property with my partner will just be split 50-50 when we separate. Is that correct?
No, it's not. Every family law case and alteration of property or property settlement is determined by the court on its own individual facts and circumstances. It is true that in long marriages where there have been no significant financial or non-financial contributions and there are no significant future needs, that the court will often come to a division of 50-50 of the assets and an equalisation of super. But that is not the most common outcome. As I say, every case will turn on its facts and circumstances. What I mean by that is often there will be a range of factors that the court considers, including initial contributions. For example, if one party or the other party had significant assets at the commencement of cohabitation or the commencement of the marriage, that will be taken into account by the court and will result in something more likely other than 50-50 of the net assets. Equally, if there have been significant financial or non-financial contributions during the marriage, by way of an example, a substantial inheritance received which overwhelms and eclipses, if you will, the assets that the parties have accumulated, then that will also result in a significant disparity in the division between the parties other than a 50-50 division. And finally, if there are future needs that each party has or one party has that are particularly significant, for example, if one party suffers an accident or injury that impairs their earning capacity, that is likely to result in them receiving an adjustment, which will mean that the division is something other than a 50-50 division.
What if there are children involved in the relationship who are of primary or high school age? How does that affect a property settlement?
That will usually impact on the second and third steps, but mainly the third step, which is an assessment by the court of future needs. If one party or the other party has had the primary care of children, and usually it is women in a heterosexual relationship or marriage that will have the primary care of the children, although that is changing. But whomever that person is, if they've taken time out of the workforce to care for children, then and are continuing to care for children, then it is likely that the court will give them an adjustment for the depletion or the reduction in their earning capacity as a consequence of that time out of the workforce. Additionally, in relation to superannuation, this has often been taken into account by an equalisation of super, particularly in longer relationships or marriages, to account for the superannuation that that party who has been caring for the children hasn't earned during the time of the marriage or relationship when they have been out of the workforce. So there's two ways that care of children plays out. It's in that future adjustment, the future needs adjustment, and in relation to the equalisation of superannuation. I believe that investing in strategic family law advice with me will assist you to know where you stand in relation to your parenting and financial matters, negotiate your matter with your spouse or have me negotiate on your behalf, and will result in a favourable outcome for you and your family.